Hopefully everybody's enjoyed it. I'm glad to see this many have stayed for the Q&A time. So I have Mike and Jenna and Gino come up here. So I was asked a question, if any question was open. As long as it has to do with constitutional literacy or how it affects the church, it's wide open. So they have a microphone, and there's a mic right here, so form a line. And Jack, go ahead, you're the first one up.
Mike, this question's for you. Regarding the Convention of the States, you mentioned the 16th Amendment could be fair game, and that you'd like to see us start over, in a sense. But then you kind of alluded to the idea of establishing some kind of a fair way for federal taxation. And maybe I misunderstood you, but I wasn't sure where you were going with that. It seems to me that before the 16th Amendment, the way the federal government obtained funds was not through direct taxation of any kind. Why not go back to a system like that where the federal government could only get funding from the states, not by taxing individuals or corporations?
Okay. The funding in the Articles of Confederation period was from the states, but the states never paid.
Never paid?
Not regularly. There were problems. They were in arrears, big time. And we couldn't pay our soldiers. We were in big trouble. The way we principally paid for the government prior to the 16th Amendment was imposts and duties. And so, for my sake, I would rather pay 50% more for a television from Asia rather than taking 50% of my income. Just it's easy to figure that out. So I didn't mean to imply any particular form of taxation. The only thing that I was saying is we need to wipe out what we've got, and we need to make it difficult to tax us. So the only thing I'm advocating really is that we have a procedural hoop that it's more difficult to impose taxes. And what that ends up being, that's beyond the scope of where we are today. I prefer flat, whatever we're going to do. I don't like graduated taxes, which are a means of socialism. That's income redistribution, not constitutionally appropriate taxation, in my opinion. So however it's done, whether it's a national sales tax or it's imposts or whatever it is, but if we get the goal of reducing the scope of federal spending, what you know is this: the constitutionally appropriate federal spending is about $1 trillion a year, meaning the national defense and foreign policy and a few things like the patent office, and there's a few other things that are enumerated in the Constitution. Our budget's a bit more than $3 trillion a year. So a bit more than 2/3 of the federal budget is improper. And so the taxes needed to pay for the proper federal budget will be a whole lot easier and more appropriate, whatever they are, than the current system we are, because getting the spending right means the taxes get right.
Mr. Farris, what's your opinion on Ted Cruz's eligibility for becoming president regarding birthplace?
Okay, well, as long as we're on this, I'll throw in Marco Rubio. Because some people say that even though he was born in the United States, his parents were not citizens at the time. So the question is, what is a natural-born citizen? And I've taught you, and Jenna's taught you, originalism as a method of interpretation. And so the best contemporary evidence is in 1790, 1 year after the Constitution went operational, there was a law of Congress relative to citizenship declaring that a person born to an American citizen overseas was a natural-born citizen, provided that his father had resided in the United States. Not a citizen, but had resided in the United States. Now that law of Congress subsequently got repealed in 1795, which means I read those two things together to say that that definition of natural-born citizen was constitutionally permissive. It doesn't mean you couldn't adopt a different definition, but that was a permissible constitutional definition in 1790. But it also tells me that Congress has the power to define what a natural-born citizen is. I think it could be, well, in fact, I think it would be constitutional if Congress decided in order to be an American citizen, you had to be born in the United States, or if you're born overseas, your parents had to be serving in the military or something. I mean, you could define it like that if you wanted to. But Congress could define it, but they haven't. And so the best reading is that if you were a citizen on the day you were born, by the law of Congress, in effect at the time, then you are a natural-born citizen for all purposes. Now, could they make it more restrictive than they is? Yes. Should they make it more restrictive so that you can't have tourists coming here and getting their kids to be American citizens? Yes. Should we stop illegal alien children from being able to be tourist kind of things? Yes. But it doesn't mean that we have done it. And so the law in question on the day that both of those gentlemen were born is they were citizens the day they were born, and I believe they're both natural-born citizens, and thus they're both eligible to be president.
Michael, let me ask you something, because again, we go back to the history. Hamilton obviously wasn't born in the United States of America. How did his contemporaries view the fact that he was born off site, so to speak, and were there conversations about his eligibility or ineligibility to hold the highest office?
There was a clause that only I'm eligible for anymore. It's if you were a citizen of the United States at the day of the adoption of the Constitution, it didn't matter where you were born. And so I'm the only living American that's old enough to still be, but I was born in Arkansas, so I'm okay. But it's an old joke, that's all. But so the short answer is, I think they're both natural-born citizens, and
this is non-issue.
It's non-issue. Now, if President Obama had been born overseas, why isn't his mother the same thing? The answer is because the law of Congress in place at the time required her to have a continuous residence that she did not fulfill, whereas Ted Cruz's mother had fulfilled. And so if, and I'm not saying one way or the other because I don't know, if President Obama was born in Kenya or someplace, then his mother could not bring him into natural-born status by her American citizenship because she failed the continuous residency test, whereas Ted Cruz's mother didn't fail the continuous residency test.
Thank you very much.
Hi, I think this is from Michael. I'm not used to this, so playing the enemy's advocate, once the Convention of States is ratified or open for business, can there be a door open for a lot of money to come in and turn it in a different direction than what your dream is?
Yeah, not realistically, and here's why. The way money corrupts, there's lots of ways money corrupts politics. Outright bribery is rare. It's soft bribery. Donald Trump has admitted to soft bribery on the campaign stages where he says, I've given money to both parties along the way because that's what you have to do business, which is saying I did soft bribes to candidates to get zoning laws done or gambling laws done. That's what that meant when you translate it out. And so that kind of bribery is real. But it's people doing business with that government that hope to get a tax break or a zoning break or some kind of government contract or something like that. Businesses invest in politics because they expect to get a return. The number that invests and would do spending for altruistic reasons is extremely small, almost to the point of non-existence. And so you have to ask yourself, are these people going to be putting out any government contracts? No. Are they going to be spending any money? No. Are they going to be doing anything that has traditionally attracted campaign donations? No. Are any of them current federal office holders? No, they will not be appointed. They could be appointed, but the state legislatures are appointing them, and the purpose is to rein in federal power, so there won't be any federal office holders appointed. By the way, they couldn't do it because you can't hold two offices of profit and trust in the United States, and this is an office of the United States arising out of Article 5. They couldn't do it. They'd have to resign from Congress. And so so Congress people and their soft bribes are gone. Can you bribe the state legislature with soft bribes? Yes, you can. But we're not there. Who bribes them? Well, it's local stuff, in soft money. It's not, the outright bribes don't happen. That much. They do happen, but they're done behind closed doors. This will be televised. Every moment of every day will be televised. The nation's focus will be on this. One of the really good side benefits is the literacy of this country on federalism and constitutionalism and limited government will skyrocket because everybody will be watching. And so people say that the fact that the media will be there will be bad. No, no, no. It will be great because the lessons, and I want to give you an example of how this really works. Ollie North is my friend. And when the congressional hearings that involved Ollie North, he was being badmouthed by Congress and beat up by Congress when they were doing their hearings. And the first day that he was a witness, he took them on, and they were bad to him and mean to him. And the people were watching it cover to cover, gavel to gavel, and the people loved Ollie North, and they beat the living daylights out of those rotten people in Congress who were beating him up. The next day, he was their best friend. They wanted to come to his birthday party. It was night and day because the public watched. When the public watched, the media had done all the media had filtered everything up until that time, and the American public didn't know what to think about Ollie North. But when they watched him for themselves, they saw the truth. Okay, you guys have seen me in action today. I fully expect to be a delegate at this convention. I think people like me, other people like me, can stand there on the floor and can get our message directly to the American people, and this country will turn around when we are able to give this message unfiltered. And beyond that, not all of them are going to be state legislators. There's going to be people like me that don't hold any office and are beyond bribing. We're just beyond bribing. And so, is it possible? Yeah. But it's such a low risk compared to the current bribery system that's in place. You have to ask yourself again, which is more likely to be bribed? The system we know that's going on where soft bribes rule the day in Washington, D.C., or this? I don't think that the way the balance, it's much more dangerous to let Washington, D.C. do all this.
So, just to clarify in my mind then, the agenda of the convention would be set ahead of time
by the states.
By the states.
Right.
By the states. So,
and the agenda is this: impose fiscal restraints on the federal government, limit the power and jurisdiction of the federal government, impose term limits on federal officials. That's it.
And nothing could be added.
Nothing can be added.
By
anybody.
Anybody.
When they do, I file the lawsuit just like I did on the ERA, and just like I did then, I'll win.
All right. Thank you.
Yeah.
Hello. I've got several questions. They're real short ones, and some of the answers I can probably find in Jenna's book. They're about the Constitution, history. I think I got the point about lawyers being, the real contributors to drafting the Constitution. I think you said 37, whatever. Anyhow, there's about 24 that weren't lawyers. The first question is, you don't have to be a lawyer to be a Supreme Court justice. Is that correct?
Technically, no. It's never been done.
Second question is, let's see, Article 3, Section 8 is, I can't remember. Article 3 appointed or established the Supreme Court in one judicial position, the Chief Justice. The remaining courts, district courts, appellate courts, were appointed under the Judiciary Act of 1789. This is a congressional act. I'm concerned about the judiciary like you are, and it is, to my mind, it's no longer a co-equal branch. If you have the final say about what the law is, you become the supreme branch. What would happen if we got an appropriate Congress and president and they rescinded through statute the Judiciary Act of 1789?
Well, the biggest problem with your question is your premise. What if we got an appropriate Congress that would do that? You know, if we had an appropriate Congress, every idea that I shared with you today could be proposed by an appropriate Congress. The chances of that being an appropriate Congress are the same as the Seattle Seahawks winning the Super Bowl tomorrow.
Oh, that's right. They're not in the.
That's right.
So are you attacking my basic premise that there wouldn't be an appropriate Congress if it was inclined to rescind the Judiciary Act of 1789?
Well, I don't think we can elect such a Congress, ever, because Washington, D.C. always affects the people, the conservatives that go to D.C. more than the conservatives affect Washington, D.C. Now, there's exceptions to that rule, but they're rare. Mark Meadows is a friend of mine. He's the leader of this small group of renegade conservative congressmen. Mark hasn't succumbed. He's been there like 4 years. Mark's great. He's on fire doing the right thing. But there's you know, a handful, maybe not a handful, but it's not 50. You know, there may be 30, there may be 40, but it's not 50 members of Congress that are as good as that. And so I just don't think that we can get there. And given the votes of the Senate, I don't see how we get to 60 votes to, you know, to do. We can't, I mean, there's just so many things that would be so much more modest than what you're suggesting that are politically impossible to accomplish. We should be able to get a marriage amendment through.
So
I mean, that would be easier. There's more public support for that than there is for the idea you have, because, you know, bankruptcy courts are gone. If we do what you say, bankruptcy courts are
All the
gone.
courts are gone, except-
You know, you can't enforce federal immigration law in federal courts. You have to go to state courts for federal immigration law. I mean, you'd be putting a huge burden on state courts. The financial cost to the states would be enormous. Who's going to fund all that? The practical implications of what you're doing are enormous. Here's an easier fix and something that we can do at the Convention of States. I think that, you know, I've told you about the Supreme Court. I would like the federal district courts to also be appointed by the states. But to have some balance, I think the idea of doing the Federal Court of Appeals the way that's done now is okay, because then you have a variety of ways that we appoint judges. So it's not all D.C. heavy. You get a little this, a little that. The more variety you get into the appointment of judges, the more likely that true justice and that the states and the people would have a fair shake in the system. So that's a much easier lift than what you're saying. Could they do it? Yes, they could do it. Would they do it? I think it's politically impossible.
The effect would be to abolish all the courts, and the only judicial position remaining would be the Chief Justice of the United States.
You could.
Is that correct?
Well, you'd have to age out all the other people. You couldn't abolish the positions of the people that currently hold the Supreme Court positions because they're appointed, you know, that you'd have to impeach them. But if you abolish their position, once they die or retire, it's gone. So, you know, eventually you could get to that point.
Thank you.
And I just wanted to add something to your point about the Supreme Court being completely final. One of the Supreme Court justices, I believe it was Justice Jackson, decades ago, said a quote that I think was one of the most fair and accurate quotations. And he said, "We're not final because we're infallible. We're infallible because we are final." And that's what really needs to change, is that there's no judicial oversight. So that's why Convention of States also really, really needs to pass, and these measures need to pass so that there's some oversight for the Supreme Court.
Thank you.
Hi, the gentleman in front of me is more honest than I am. I've been spending quite a lot of time trying to morph a bunch of questions into one because I thought we'd only got one. And I sense, because you were, and if this sounds challenging, I want to thank you, Mike, for your yeoman service for decades. But I wonder if some of the ideas for this came from the frustration of the failures of the religious right that you saw at the beginning of in 1980, and we haven't been able to achieve a lot of things even when we elected people we wanted to. And both in the morning and the afternoon, you referred to human nature, which I don't think we can ever, sinful human nature. We can't ever leave that out of the equation. That's what most ideologies leave out of the equation. Having said all that, you gave the impression that if we actually achieved what you're trying to, it would be pretty much irrevocable. Just one example, the government...
Can I stop you?
Sure.
Because you've asked already two really good questions, and I don't want you to go to the third. Let me answer the first one. Help me remember the second one. But about the, is this the failure of the religious right? Is that the reason we're doing this? And then secondly, would it be irrevocable? And if you got a third, we'll come back to it, okay? All right. I have had the privilege of living through the only successful area where the religious right has been successful. If you look at abortion and ask yourself, is it any better in the last 30 years? The answer is no. You look at pornography and you ask yourself, is it any better? The answer is no. You look at homosexual rights and you ask yourself, well, you don't even have to ask yourself. The answer is no. The only area that's better, by the way, I have worked on all of those things. I have represented pro-life issues in court. I've written anti-pornography laws. The law that I wrote for Washington State was challenged in the Supreme Court of the United States. They declared one word of my law unconstitutional, the definition of prurient interest, where it says that which appeals to lasciviousness or lust. They struck the word lust, said it was unconstitutional to use that word, and left in lasciviousness. You go to a dictionary, and lasciviousness means lust, which means it's unconstitutional to use short words. So I've worked on all those things, and we've not had any success. In fact, we're worse off in most of those areas. The exception is the right of parents to direct the upbringing and education of their children. It was illegal, according to the government officials, it was illegal everywhere to homeschool your kids in 1980. We said no, because the Constitution is the highest law of the land, and it says otherwise. We don't care what your nice little state statutes say. We say the Constitution is otherwise. We fought that not against one union, one powerful lobby. We fought, the teachers' union is the most powerful group politically in any state legislature. They often go against, like the State School Boards Association, the State Department of Education, the Principals Association, the Superintendent's Association, management versus labor. On our issue, homeschooling, all of those entities were aligned together against us. We took on the establishment that way outnumbered us. We had truth, we had God, and we had courage. And we fought, and God blessed, and we've won state after state after state. I don't believe we can do this because of failure. I believe that we can do this because I have been privileged to help lead a group to success nationally in all 50 states. And so, the opposite is true. This arises out of a record of success, not out of a record of failure. Your second question.
Third question.
Well, okay, the third question, whatever. No, but the question about, is this a permanent solution? No. Nothing is a permanent solution. The Constitution was not a permanent solution. Amendments are not a permanent solution because the price of liberty is eternal vigilance. The permanent solution is an activist group of citizens, I'm too tired to say citizenry, that never goes home. That's the permanent solution, and it's the only permanent solution. Teaching your kids to believe in liberty is the permanent solution. That's the permanent solution. So and let's say we did all this and it lasted for 50 years, and then it completely got reversed 50 years from now. You know what we did? We did a really good thing by giving America 50 years of liberty, and if that's all it was, I don't think it'll be limited to 50 years. But if that's all it was, it would be well worth doing because we gave a couple of generations the opportunity to have liberty for themselves. You got another question?
Well, you actually kind of made the third one moot, but one last point. The third one was, obviously, the Prohibition Amendment was repealed not long after. So the populace, the moral state of the populace has a lot to do with how these things go. But going back to the RFRA and the coalition that put that together, you made me think of school choice, which in Wisconsin is a big deal. And it became successful and passed because we had a liberal Democrat mayor in Milwaukee who saw that inner city schools were failing poor black kids. And he wanted to give the parents choice. So it was conservatives, but there were also black legislators. Howard Fuller, who was the head of the school board for a while. The alliances between our, quote, our side and people on the other side of goodwill, I think can lead to some pretty helpful, lasting victories.
I would welcome that, and we work on that all we can, but we're not going to delay time is of the essence. I don't believe that we have 10 years to turn this country around. If there's not hope for the people, and if we're not moving dramatically in the right direction by 10 years. So I don't have time to wait for the left and other people to, wise up. If they want to wise up and join us, great. We're not doing anything to turn people away on partisan or socioeconomic or any other way. We want to be inclusive in that way, but I'm not going to wait for them.
Thanks.
Thank you all for the seminar today. This question may be for Gina. Since we live in a postmodern culture with the media and upper education redefining words to hold relative and two contradictory meanings, how can we fight against that if they want to change the meaning of the words in the Constitution?
Well, one of the things, I think Convention of States is really the idea, and also education. Certainly educating ourselves and becoming aware of where the Constitution arises from, where it originates, that it has a plain originalist meaning, and advocating for that is really, really critical. And so, a majority in terms of having the American citizens and the the grassroots really understanding where the debate is. That's one key aspect. The second thing is exactly what the Convention of States Project is doing by saying we don't want to have these Supreme Court justices that are going to continually redefine all of these terms. They're lifetime appointments. They're doing whatever they want with a postmodern and secular humanist worldview. And so we want to have term limits and make sure that other people are appointed and have some of these very practical changes. So it's twofold. We have to educate and become aware of the problem and then actually have a solution to the problem. So I think now we're aware of the problem, and hopefully more and more people will become aware of it. And Convention of States is the greatest step that we have in order to really solve that problem. So do you want to add anything?
Just not about what you talked about, because it was great. But the biggest way to fight postmodernism is to make sure Christians aren't raised in postmodern philosophy. And so parents need to make sure that their kids get an education that's not most postmodern in character. So parents and pastors are the line of defense there. I don't worry about what the world does. I worry about what God's people do. And the problem is that way too many of God's people, God's math is this: 1 can drive out 1,000, 2 can drive out 10,000. But if we don't have enough believers to form that little nucleus of Gideon's army, we're toast. And so I don't really care about whether I get to 70 or 80 or 90%. I don't care. I care about getting 70, 80, 90% of believers to understand the right thing. We get there, the world changes.
Thank you.
I want to thank you for accepting God's challenge. It's just, anyway, this is a little off topic, but it's really eating at me. California approved voting for illegal aliens, and are we going to get down the road and find out that their votes count? I mean, that's not fair to the other 49 states.
I don't know the status of that. I know it's being discussed, and whether it's final or not in California, I don't know. California could do that for California elections if they want to. They want to do that for federal elections, for Congress, or for the president. They're going to have a fight on their hands, and we'll go after it. I mean, may not be personally in it, but I've got friends that are part of the gung-ho legal community in Washington, D.C.
They would be losing their votes.
We'll go after it. We'll go after that. And I don't think they could possibly win that issue in terms of constitutional issues. And if they did win, it would be the quickest constitutional amendment you ever saw, and it would be so quick, it would get through Congress. And so the uproar in America for that, so if California wants to shoot themselves in the head for state issues, go for it. You know, let them.
All right, thank you very much.
Let's go ahead and we have about 6 minutes, so whatever we can get through in the next 6 minutes, because I know these guys are wiped out. So real quick on the questions.
Being a member of Homeschool Legal Defense, thank you, Mike Farris. Because we became a member of that probably about 3-4 years ago. We were in Colorado, then went to Wisconsin to take care of my mom, and we're back in Colorado. But what hit me was we met a family who said, well, we were at the border where Michigan hits, and they were like, well, I'm going to homeschool Michigan because they don't have any homeschool laws. And then I'd watch your cases come through that the social workers were taking all these kids, or the doctor who said the kid who had cancer, and she wanted to keep putting her opinion forward on that. And I thought, even if it had no homeschool laws, she thought it was safer. But a lot of the cases were out of Michigan that supposedly didn't have a homeschool law for protection, were taking these kids away. The social workers were coming in. And I guess I get a little confused on parental rights versus the homeschool rights as being, you're saying they're all by state. So like when those social workers, go over the boundaries and stuff like that, and I appreciate the fact that you go after them, because they just go, sorry, here's your kids back, and they walk away. And you go, wait a minute.
Well, I think I got the gist of it. The question is, kind of like, does a good homeschool law guarantee parental rights safety in all areas? The answer is no.
I guess so, yeah.
And so does a good homeschool law guarantee homeschool safety? No, there are about 16,000 school districts, and every year some superintendent decides the law of the state doesn't matter. He's going to make his own policy, and so he's going to win the stupid award, and we're going to go after him. We don't do every bit of parents' rights litigation, but what we do for our members is we battle for the front door, their right to get in the first place. And that, a lot of the times, that's the whole game, is the battle for the front door. And so it doesn't matter what state you're in, there are risks, but the good news is the Fourth Amendment to the United States Constitution is applicable everywhere, and we have never lost this principle. Sometimes we live on facts, but we've never lost the principle. The Fourth Amendment to the Constitution applies just as much to a child welfare investigation as it does to searching for murder evidence in a criminal case. They're exactly the same for Fourth Amendment purposes. And so we win that routinely. Sometimes the facts are bad, sometimes the facts are good, but the principle has been exonerated time and time again. Thanks so much.
Thanks.
This question has to do with when I can't even say the name, Obergefell or whatever.
The same-sex marriage case.
Thank you.
Yeah, you're welcome.
That's better. When that, and the clerk, I believe in Kentucky, decided not to issue, and they framed that up as a Religion versus the Homosexuals Act or whatever. They framed it up as that kind of issue. But really, Kentucky at that point didn't have a state law under which to issue, did they? It seemed to me that the executive had placed itself in direct service of the SCOTUS ruling.
So that case, the Kim Davis case, is the best way to illustrate how lousy a weapon nullification is. People say, well, you can just nullify the laws. Yeah, right. Try nullifying 200 volumes of the Code of Federal Regulations. They're all unconstitutional. You'd be playing whack-a-mole forever to try it. Just try to do it, and the federal courts will whack you. Kim Davis was not trying to nullify the law. She just wanted her name off the marriage license. That was the sole thing she was trying to accomplish. And even that little modest effort, the federal courts took out their big, bad club and beat the poor lady to a pulp, which shows you the bullying nature of the homosexual community and the federal courts. They were getting their marriage licenses, but they wanted her name, they wanted her to bend the knee herself. And that finally they were able to get her name because of state law off the marriage license. Didn't stop the licenses. There was no effort in Kentucky to stop the licenses, nor would it be successful if they tried, because the federal court would, literally beat them to death. The only way you could stop them, if you wanted to, was for the governor to declare war against the federal government, call out the National Guard, and start shooting the U.S. Army when they invaded. That's what it would take. It's the only way you could stand up to it. Because if the federal government wants to enforce it, they will. If they don't want to enforce it, as you see here in Colorado with your marijuana laws, they're happy as clams to not enforce the federal marijuana laws and let Colorado do its thing. It's selective enforcement depending on what their political agenda is. But they would send the military into a state that refused to enforce the same-sex marriage laws. I don't want to fight them with weak weapons. I want to put the spike in the heart of the vampire by taking away the Supreme Court's power to do this to us ever again.
Mm-hmm. My question, though, was at the time she was literally jailed for failure to issue, there wasn't a state law for her to go to because
no,
she
was being held to be in violation of the 14th Amendment to the United States Constitution, which she is required. The 14th Amendment, in theory, does supersede the state law. If the state law says black people can't go to school, the state law is unconstitutional. The 14th Amendment rules. And so, according to the Supreme Court, it's the same thing. When they say that about racial discrimination in education, the Supreme Court was right. When they say that about same-sex marriage, the Supreme Court is wrong. But the nature of the power is the same in both cases. It is an overriding power, and they correctly crushed the states who were practicing racial discrimination despite the clear words of the 14th Amendment Equal Protection Clause. They were violating equal protection and the core original meaning of equal protection when they did that. But even when you pervert the Equal Protection Clause, the same federal power is there to crush dissent.
Clarification on, you talked about the Commerce Clause and that it at the time meant shipping, but you said something like mining would not be involved. What if like, say, coal is mined but shipped across state lines? Wouldn't it pertain at that point?
Sure, they could regulate the shipment of coal, but they couldn't discriminate based on the product. They could say coal has to be shipped safely. They have to. The purpose of the Commerce Clause is to make sure that there are no trade barriers for the movement of goods, so they move safely and without trade barriers. And given your good comment right now, if you made that suggestion on the floor of the Convention of States, I'd say, okay, I got it. Couple words, we got it fixed. Because we can make sure that when we say shipping, we don't mean using shipping as a pretense to insert substantive laws. One sentence can fix what you just said. It's a good suggestion. I know how to fix it, and we can get a sentence to make sure that doesn't happen.
Would the Commerce Clause pertain to almost anything, like things are, like crackers are baked, put in a box, shipped across state lines?
At the moment they get in the truck, yes, but they can't control the production of the crackers themselves.
I see. Thanks.
Yeah.
Okay, we'll take these last two and wrap it up.
Thank you all for doing this. My question is to Gino.
I get a question?
Yeah.
I'm just teasing. Go ahead.
How can we get this into churches? Like I go to one church here in Denver, but I've lived in 2 other states, and I want to get it into churches all around.
Yeah, I think that one of the ways that we get it into churches, again, is we remind our family, we remind our friends, we remind our church family and friends that these important issues matter. In Colorado, more and more risky kinds of things are coming up. You mentioned the baker and the photographer and the florist. But now churches are also, Mike, dealing with transgender, where we have a church up north that a person who in their congregation had a sex change from male to female and then wants to go on the women's retreat. And the church itself, wonders, well, is this a good idea? Is this really who we are and what we want to do? They're not trying to be mean or weird. There's a lot of issues that are at stake. And what Michael and Jenna have brought up is we've got to address these issues. And so part of the challenge is that the churches themselves and the pastors themselves have to come to grips with the fact that this is going to affect me and my church, and this is going to affect the people in the church. We want to come up with a solution. And here's the way I would put it. If we want to come up with God-honoring solutions to the problems that we face, we can no longer ignore these issues. And so that's the kind of conversation I would have with the pastors and leaders of churches. We want to come up with God-honoring solutions to the very real problems that we face in order to honor Him and glorify Him and preserve the witness. Obviously, to me, the overarching issue that I look at when I'm looking at candidates is this candidate going to provide an atmosphere where I can proclaim the gospel, where I can worship God, disciple the saints, and reach the lost? That, we all have different issues that are important to us. And so I think that that's what we have to come to grips with and tell our pastor and church friends. If these issues are important to you, these are the things that we're going to have to do. Mike, you might want to add to that there's some common sense things that we can do to encourage pastors and leaders to respond.
The simplest thing I know that's easy is the DVD series that I've done. Well, you can do it as an adult Sunday school class or a youth group class. Some churches have done it as Sunday night church. I wouldn't recommend doing it on Sunday morning. That's not the right place and time. But the auxiliary teaching times of the church, teaching about citizenship is important. And the last session is on the Convention of States. So, they get the whole, they get detailed on Commerce Clause and all this stuff and religious liberty, and the whole bit, and then we tell them what to do at the end. So it's a little different format, but it's essentially the same themes as we covered today. And so, just take it, and you have to have permission from the author, me, to show it in a group setting. You got it. But I do request that if you show it to a lot, my definition is if you show it to more than 1 million people, please come ask me again. But the first million's on me. You can do it, okay?
Thank you. I feel so blessed. You are wonderful people. But I am frustrated with the 14th Amendment. I'm really frustrated with the intent behind that amendment because it's the first one that calls us subjects and subject to the U.S. government. And then if you read further into the 14th Amendment, it says that the Native people, the Native Americans, are sovereign. But look at where they are. Look where the U.S. government put them. I'm still frustrated with that 14th Amendment.
Well, the phrase in the 14th Amendment is in the citizenship definition, is that if you're born in the United States and subject to the jurisdiction thereof, which is a legal term. And subject to the jurisdiction isn't the same as saying a person is a subject. It's a legal term of art. But
it causes frustration.
Well, it may cause frustration, but my suggestion is understand the original meaning, not of the word, but of the phrase. And if you understand the meaning of the phrase, it's like in the literal meaning of when David went into the cave, or when Saul went into the cave and David was hiding and he cut off a piece of his robe to show that he was there and he could have killed him and he didn't. It said Saul went into the cave literally to cover his feet. It meant go to the bathroom, but it said cover his feet. And so if we got all fixated on the exact word and didn't understand the meaning of the phrase, we would be led to the wrong conclusion. And subject to the jurisdiction does not mean we are subjects. Means that in order to be entitled to be a citizen of this country, Congress has the ability to make sure that you're here lawfully, that you're a part of the system. And that's what it means. Subject to the jurisdiction means you're a part of our law, you're a part of our country, and you're voluntarily living under our laws. It doesn't mean that you are a subject, not a citizen. So it's the whole phrase that matters, not the word. And I think, I get it. I don't want to be a subject either. But what makes us subjects rather than citizens is where the Supreme Court gets to decide what the law is when we are not practicing self-government. We are subjects every day. You're right to, you don't want to be a subject. But don't worry about that phrase. Look at what the president does when he writes a law and says, this is your gun rules. You're going to do it. You're a subject. When the Supreme Court says, I don't care what your vote is in Colorado, you got to do this on marriage, then you're a subject, because tyrants have subjects. And I pointed out to you time after time after time where tyranny is reigning in this country. We are subjects in so many ways because we're not behaving like citizens. And so you've got the right instincts. Focus your weapon on the right problem, and let's go to war together, okay?
One of the illustrations that I would use, again, when Paul is arrested and he's beaten and he points out to the Roman centurion, excuse me, I'm a Roman citizen. I thought it was unlawful to beat me without due process. And the Roman centurion gets understandably upset because the Roman centurion knows that if this Roman citizen's rights are undermined, that the centurion is subject to the emperor, he can be put to death. In other words, this is a judicial system that understands what citizens' rights are. And so when Paul asserts his rights, that he is asserting his right as a subject of Rome, but he never abandons his citizenship in heaven in the process. And that's the balance that we've got to think about for those of you who are Christian and who embrace a biblical worldview. We're citizens of two places, heaven and earth. And it's okay for us to assert the rights and responsibilities of both of those citizenships. And so, yeah, that's
well, and our state constitution calls us sovereigns. And I'm curious as to why in the 14th Amendment they designate the native peoples as sovereigns, but then they don't designate us as sovereigns.
I think part of the answer to that is that the way that law is done, that they have the right to self-governance, that the way that they identify problems, solve problems, that the United States recognizes that the native peoples have certain rights that have been extended to them.
But they don't observe them.
Yeah.
That have been entered by treaty that you talked about.
Right. See, I get frustrated with the situation with reservations and tribes and gambling and all that stuff from time to time. But the number one rule of international law is pacta sunt servanda, which means keep your promises. And so in the biblical sense, it says, he who swears to his own hurt and changeth not, he will be blessed. I wish we hadn't made some of these promises, but we did. And I think that we will never be blessed when we don't keep our promises. And so if we could wave a magic wand and do the promises over, there's a lot of them I'd like to undo. But I still believe that we should keep our word.
Okay. Let's give them a hand. Thank you, Mike, Gino, Jenna. Okay, thank you all for coming. Have a safe drive.